Okay, let's start again. Now, I've just given you some general concepts of security and so on. At this point, I must distinguish between what I've been referring to as security, which in civil law from countries you might think of as rights in rem, okay, from guarantees. Now, in English law, a guarantee is not a right in rem. It is simply a contractual undertaking by the guarantor to see to performance by the debtor of the guaranteed obligations. That's the technical way that English law thinks about a guarantee. So it's nothing more than a contractual obligation. Of its nature, it's contingent because until the primary debtor defaults, there's nothing that the guarantor needs to pay up under the guarantee. Once the primary debtor has defaulted, then the guarantor has to pay, and so his contingent obligation then becomes what is called an actual obligation. But it is just a contract. And so even after it's become an actual obligation, it is still an unsecured contractual obligation. If the bank wants better than that from the guarantor, then the bank or the creditor must take security from the guarantor to cover his obligations under the guarantee. And that security can be phrased as, this is security for the performance of us of our obligations once they become actual. So the bank can't enforce the security until the obligations have become actual, but the bank's sitting on that security as its protection. If the guarantee is never called and the primary debtor repays, then the guarantor's security will be discharged. But until then, the bank can sit on that security for the guarantor's obligations. Now, I refer in your notes next to concepts of set-off and netting, and I've done that deliberately because although, strictly speaking, they are not rights in rem as such, they are as good as, if not better than, rights in rem. Let me just explain that by an illustration. Let's say that I am a bank and I take a guarantee from you. And let's say the value of the guarantee is £100. So what it's securing is the primary debtor's liabilities of £100. If that's as far as we get, then your obligations under your guarantee are unsecured. I've got a contractual claim against you, but that's all. I could take security from you over Blackacre or whatever asset you want to give me, but I might alternatively say to you that you must deposit in an account with me £100, which I can then grab if I need to call the guarantee. And the primary mechanism by which I can do that is by exercising my right of set-off. Now, essentially, to understand that, we need to understand the relationship between you and me with respect to the £100 you've deposited in the account with me. So, and this applies with respect to any deposit. You go to the bank and you deposit into an account £100. So you've got a deposit account and the balance sitting on that account is £100. What's the legal relationship?
You have a claim against the bank?
Yeah, the bank is your debtor. So, the bank owes you £100. The bank then calls the guarantee so that you owe the bank £100. And the bank grabs the money sitting in the account and applies it, and that's set off. So, setting off one claim against the other to achieve a balance of whatever the net amount is at the end of the day. And that's set off. That's how set off works. Now that's a very simple example of essentially banking set off. But set off can apply in a much broader range of situations. There is legal set off, which is essentially a procedural device in litigation. A has a claim against B, B has a claim against A. In the ultimate judgment in the two actions, we finish up at a net figure by the exercise of legal set-off. It's a procedural device. Alternatively, you and I have a contract, say a construction contract, under which I have commissioned you to do some work for me. And I have to make payments to you under the contract as you do the work. But it arises that you've done the work badly. Then I might be able to reduce the amount that I've got to pay you by the value of the claim I've got against you for your defective work. And that's called equitable set-off. Now, whereas legal set-off is just a procedural device to achieve a net amount in litigation, equitable set-off, in theory, the word is impeaches the claim. So it's almost inherent in the rights of the parties that situation of set-off might arise. And that's substantive. Now, the reason why I've just made that point is, when we then feed into that a conflict of laws scenario, legal set-off is an English procedural device in litigation. It may not apply in Ruritania or wherever the claim is. Whereas if the claim's in Ruritania but the contract is governed by English law, then the inherent rights in the contract should apply in the resolution of a claim on that contract, even if it is in Ruritania. So equitable set-off as a part of the English law of contract should apply. That's all well and good until one of the parties goes bust. And at that point in English law, everything I've just told you goes out the window, and instead we have rules of set-off in insolvency. And the English insolvency rules of set-off are basically designed to achieve a settlement between the parties of their mutual claims between them, so that you achieve a net balance in the insolvency as between those two. Now, not all jurisdictions do that in insolvency. But let me just give you a sort of an example of how it works in English insolvency. Assume that we've got a bank and its customer. The bank has lent £100 to the customer, and the customer has lent £50 to the bank. In other words, the customer has deposited £50 in its account with the bank. The bank, on another deal, has lent £100 to the customer. The set-off position is what? 50, yeah? So in the insolvency of the customer, the bank is a creditor for 50, not for 100. So from the bank's perspective, that's much better than being a creditor for 100 and having to hand over the 50 to the liquidator to be put into the general pool of assets, in which case the bank may get much less than the 50. Now, yeah.
Wouldn't in such a case then the bank have a preferential status for the other creditors?
Yep.
When it was mentioned before,
It's
should include also the banks or the creditors that are in the set of situation.
It's better than security. It's because it's easy to work it out. You don't have to go and sell the asset. It's just an accounting exercise. It's the best thing a bank can have.
Does this set apply only to banks, or is it possible?
No, everybody. Everybody's in that pot, and you cannot contract out of it. It's compulsory. So the best advice I can give you is only deal with people who owe you money, so that when you go bust, it won't be so terrible for you. Yeah.
But what's the point of deposit for the borrower?
What's the point? Okay, let's change the scenario a little bit. The borrower's deposited £50 with the bank, and the borrower is not a borrower, he's a guarantor. Okay? So we don't know whether that guarantee will actually be called, but if it is, the bank wants to grab the 50 against the guarantee. So it's in effect, it's the bank taking security. And for a very long time, that particular scenario I gave you caused problems. Until 2003, when the insolvency rules were changed to make it absolutely clear that it would apply in that sort of guarantee situation. Let's move on then to thinking about conflict of laws. So up till now we've been living in this glorious island of England, and we've ignored the rest of the world. Now we have to take into account the rest of the world and feed in those conflict of laws types issues that I referred to at the very beginning. And an important point just to note at the outset is that conflict of laws rules are territorial. Each jurisdiction has its own conflict of laws rules, and they're not necessarily the same as any other jurisdiction's conflict of laws rules. So while I, as an English lawyer, can try and analyse a cross-border situation and say how I think an English court would resolve all the jurisdictional and different legal regimes that are applying, I can't guarantee that a lawyer sitting in France, faced with exactly the same scenario, would come up with the same result. Now, why is that statement wrong? Why is the statement that I've just made about 20 years out of date? More than 20, almost 30 years out of date. Sorry? Well, we're all members of this glorious thing called the European Union, and there is now some coordination of the rules. And we'll look at this in a little bit more detail later, but there are now the same rules under Rome I and Rome II. Rome I dealing with contractual obligations, Rome II dealing with non-contractual civil obligations. And there are also some common rules in insolvency. So maybe I should change the example I gave you and take ourselves a little further afield to a more dodgy jurisdiction, let's say the United States of America. Now we are in a different world and we are applying different rules. So a judge sitting in the High Court in England will be applying the English conflict of laws rules. A judge sitting in the Supreme Court of Texas will be applying Texan rules, which, by the way, may be very different from the rules in the state of Louisiana. Now, how might all this come about? Let's just think about a cross-border finance transaction. So we've got a bank in London lending money to a borrower established in this wonderful country called Ruritania. And the borrower in Ruritania in turn owns assets in a country called Pacifica and in another country called Absurdia. So just think about all the cross-border issues that arise there. We've got a loan agreement between a bank in London and a borrower in Ruritania. So what law is going to govern the relationship under the loan agreement? Is it going to be the law where the lender who's supplying the money is, or the law where the borrower who's paying the money is? Sorry? Yeah, maybe we can deal with that by choosing the law. So maybe in our contract we can say this law will be governed by the law of Scotland. Can we do that? Where the law we choose has got no relationship to the geography of the situation? Yes. Yeah, we can. You can do that as a matter of English law. Whether a judge in some other bit of the world will say you can do that's another matter. So, okay, we think with the loan agreement we can say you're borrowing money from an English bank, we're going to play by the English rules because we like the colour of the English judge's wigs or whatever. Yep. Okay. Next question. The bank wants to take security over the assets in Pacifica and the assets in Absurdia. English law? This mortgage is governed by English law, and God help you if you don't agree with that. Now, 100 years ago we dealt with that. We sent a gunboat if they didn't agree with it, but the Navy's not up to what it used to be, so that's not going to work any longer. So, what law are we going to have? Make it simple. Land. Lex situs, yeah. I'll tell you a real example. When the Soviet Union broke up, I was involved in a transaction to lend money to build a hotel in Moscow, and the Russian law on mortgages hadn't sort of really got written at that point. So everybody said, oh, well, that's easy. We'll just say the mortgage is subject to English law. And I said, oh, yeah, and how well will that go down in front of a Russian judge when we need to enforce the mortgage? And I think the answer was, well, it'll be a matter of money. But, so you see, we've now got a problem, haven't we? Because we've got to apply the rules of the lex situs because we're dealing with land, and the basic English conflict of laws rule, where you're dealing with that type of asset, is lex situs. And maybe the lex situs in Absurdia is different from the lex situs in Pacifica, and in turn they're both different to the law of England. What about goods? So the asset that we're actually sort of wanting to take security over is presently located. One of them is presently located in Pacifica, and one of them is presently located in Absurdia. What law are we going to apply now, bearing in mind that these are movables and they move? You know, aeroplanes, ships, railway, rolling stock, lorries, whatever. Again, the English conflicts rule to start with. What would English law say is the law that would govern that? Well, English law again falls back with tangible movables to the lex situs at the time of the transaction, which is fine if you know what the lex situs is and where the asset is and it doesn't move. It's not fine if any of those things change or we can't work them out. I'll give you an example. A case called Christie and Winkworth Manson. There's a painting hanging on a wall of a posh house somewhere in the West End. And they go out for the night, and when they come home, they look on the wall and the painting's gone. A few years later, as one does, they're looking at their Christie's catalogue, and lo and behold, up for sale at Christie's is their painting. So they get on the phone to Christie's and say, hang on a minute, you know, that's our Picasso or whatever. We want it back. Now, English domestic law, a thief cannot confer a good title. And something like a Picasso, you would get an order for its return. But when the facts were looked into a little bit more carefully, the guy that was putting the painting up for sale had bought the painting in Italy. And under Italian domestic law, there's a concept of bona fide purchaser taking for value and without notice. So as a matter of, and no doubt all the Italians amongst you are going to tell me I've got this wrong, but let's assume I've got it right. And yeah, that's what the English judge said. So under Italian law, the purchaser, being an innocent bona fide purchaser taking for value and without notice, got good title. So who won? The painting's back in England, from whence it should never have been removed, and if we're just looking at this as a matter of English domestic law, the title stayed where it had been originally, but we've put into it a conflict of laws scenario. English law says that title is determined by the place, the law of the place of the last relevant transaction. So an English judge applying English conflict of laws rules, therefore applying Italian law, the person who bought the painting in Italy was the true owner, even though the painting had now come back to England because there'd been no further transaction in relation to it. So he could sell it at Christie's. Now just think about that in terms of financing transaction and movable assets that will move. And you can see you start running into huge problems. And it becomes even more difficult if you're talking about intangible movables, because either you've got to sort of try and allocate a notional situs if you're going to apply some sort of lex situs rule, or you've got to think up some other rule. And if you look at Rome 1, you'll see that it does think up another rule, which is the governing law of the intangible, which is fine so long as the judge that you're before is applying Rome 1, but not fine if the judge is in a non-European jurisdiction and isn't applying Rome 1 but applying his own or her own conflicts rules. And as I just say as the last point there, this fallacy that you can cure all these problems by just writing everywhere English law applies, terrific. No, it's not. It gets a bit more complicated still when we feed in insolvency into all of this. Because not only are we sort of thinking about those issues I've just talked about, but we're now thinking about, okay, where are the insolvency proceedings going to take place? What law will govern the insolvency proceedings? And again, Lehman Brothers is a great example of this. In Lehman Brothers, the Lehman Brothers organization was operating in about 100 jurisdictions, involving more than 100 companies in the group. And some of those companies operated across border. So when Lehman Brothers, the whole group, went spectacularly bust on a weekend, there was a mad scramble on the Monday morning for insolvency jurisdiction. Where are you going to have your insolvency? Is there a risk that you'll have competing insolvency claims going on in different jurisdictions? And how ultimately do you resolve all of that? Because there's not much point in having 100 different insolvency proceedings all applying their own insolvency rules. For instance, if you're going to do that, in what jurisdictions should any particular creditor prove? Can a creditor prove in different jurisdictions and in different insolvencies for the same debt? Do you take into account in jurisdiction A the value of the creditor's claim in jurisdiction B, or do you ignore it? Right, what does English law do about all of that? Well, I'm going to start at the bottom and sort of work my way up. The basic position in English law is to try and achieve cooperation. To try and work out what ought to be the principal insolvency jurisdiction, and then assist that jurisdiction with a problem, however, if the rules that that jurisdiction apply are fundamentally different to English insolvency rules, then you do get a problem. But subject to that, the English courts will say, if, for instance, you're dealing with an American corporation, that the principal insolvency jurisdiction should therefore be the state in which that corporation is incorporated in America. Therefore, US bankruptcy law. So that's the basic common law position. If you want to see that more fully explained, have a look at what Lord Hoffman had to say in the Privy Council in a case called Re-Navigator Holdings, 2006 UK Privy Council 26, or 2007 1 Appeal Cases 508. But on top of that now there is a layer of statutory provisions. And I've just outlined them for you. First and foremost, there is the EC insolvency regulation, which tries to set out a set of rules within the EU as to insolvency jurisdiction and cooperation and what rules should apply and so on and so forth. To that, there is a special set of legislation for credit institutions and insurance undertakings, those being currently directives. And there is also now in the melting pot for credit institutions the Banking Recovery and Resolution Directive, which was sort of agreed in principle last December. And you've probably also seen the discussions that are going on for what's called a single resolution regime to deal with failing banks within the Eurozone. So there is at least some standardization now where it's an EU context. Internationally, there is the UNCITRAL model law on cross-border insolvency, which was introduced into as a part of English law by the 2006 regulations. In many respects, the concepts are similar to what you find in the insolvency regulation. On top of that, I've just mentioned some bits of the Insolvency Act. Section 221 on its face looks extraordinarily wide. It says basically that the English court has the power to wind up any foreign company, which takes us back about 100 years or so. In fact, the judges have interpreted that as only if it's got a relevant UK connection, and only then with respect to assets in the UK. And there is also section 426 subsection 4, which requires the English court to cooperate with insolvency proceedings in relevant countries, which is basically the members of the Commonwealth. Right, we've looked at all of that. Let's now go back to English law and security. I want to give you a scenario. Just put yourselves in mind of a banker, and wash your mouths out with soap before you do anything. Think about this scenario. Someone's come to you and said, we're setting up a subsidiary company which is going to run a supermarket business. And at the moment it's got no assets, but we want you to provide the finance for everything to do with it, i.e. acquiring the land, building the supermarket, fitting out the supermarket with fixed assets, providing working capital to stock it with food, which we can sell. So you think about that and you say, okay, in terms of the finance, you need long-term finance for acquiring the land and building the building. That sort of thing traditionally is long-term because it takes a long time to generate the money to pay off the capital finance that you needed. So we're looking at a long-term loan for that bit of it. And in terms of sort of assets, we're thinking about the land with the building on it as part of our security package. Now remember what I said before, that we could tie the assets into specific finance, or we could make the assets generally available for all the finance. So chances are the bank's going to go for the second of those, isn't it? So land and buildings as an asset for all of the finance to be provided, but the finance for the acquisition of that likely to be long-term. The plant and machinery that we're going to put into the supermarket, so the shelving, the refrigerators, the computers, the stuff that makes bread. You ever noticed when you go into a supermarket that there's a smell of freshly baked bread as you go in through the entrance? That's a trick that they have to make you spend more money in the supermarket, because it puts you in a good mood to go and spend money. So put a nose peg on as you go in so that you're not beguiled. So we need money, we need finance to equip the supermarket with the sort of capital equipment to run it. Shelving, refrigerators, computers, that sort of stuff. Yep. And we would quite like to include those things once we've bought them in our security package. Now, of their nature, they're not going to last as long as the land and the buildings, are they? And they're going to have to be replaced from time to time. The refrigerators will wear out. The computers will become obsolete and have to be replaced by new computers. But certainly in an accounting aspect, we would think of those as fixed assets. Yeah? They've got a degree of permanence, but not nearly as permanent as the land and the buildings. And then we're going to have to fill the thing up with all these wonderful shelves and the refrigerators and so on. We're going to have to fill up with food that the supermarket's going to sell. So we're looking at a working capital facility to provide the finance to do that. Now, it would be a pretty bad business if it didn't need money to replace those items. You know, if we've got a whole shelf of baked beans, we want those baked beans to be flying off the shelves as much as possible and being replaced by new cans of baked beans. We want the supermarket to be buying flour to make bread, to sell the bread, more flour, more bread, more selling bread. So that finances a working capital facility which will be turning over, as will the goods that are purchased using that finance. But it would be very nice if we could also include all of that in our security package, because it's worth something. It would be awful if we just sort of take the view, well, you know, it's a lot of money in it, but it's not much use as security. Especially if it's wine. You know, at the worst, the banker might want to drink it. So our supermarket has its big opening day, and all the people come in, and the baked beans are flying off the shelves, and the bread's flying off the shelves, all going in a shopping trolley, and people go to the counter to pay for it. Now, they could pay in cash, either notes or a debit card, but they might typically pay using a credit card. Now, as between the shop and its customer, that's an effective method of payment. And essentially what's happening there is that the supermarket is parting with the asset it had previously, can of baked beans, and replacing it with another asset, debt due by the credit card company to the supermarket, which will probably get settled every 6 weeks or so. So over each period of 6 weeks, that's going to mount up and be quite a valuable asset, is it not? And it would be very nice if our security package could include that as well. In fact, it would be lovely to include that, because that inevitably will turn itself into cash, so we won't even have to sell cans of dodgy baked beans to exercise our security. Is there anything else we might think about in this package? Well, supermarkets probably got a brand name. Let's assume it's a trademark, so it would be quite nice to include that as well, yeah, in our security package. And it may have come up with such a wonderful new method of making bread that there's a patent. So we'd quite like to include that as well, yeah? So, all of these things we're looking at as potentially part of our security for all of that money that we will provide and continue to provide for the working capital facility. And then on top of that, I told you that this will be done through a subsidiary company. So we've got the parent company, and we might want something from the parent company. What? A guarantee, yeah? and then we might want to take security from the parent for its obligations under the guarantee. Question: could we, just to make life simple, forget about taking security from the subsidiary for its debts and achieve exactly the same thing by taking security from the parent over its shareholding in the subsidiary? How about that? Much simpler if we could do it. No need to worry about a mortgage of the land and all the rest of it. We've clobbered the whole lot because, after all, the shareholders own the company, yeah? And back we come to our case of Salomon, yeah? We established, did we not? Salomon and Salomon, corporate veil. The assets and liabilities of the subsidiary are the assets and liabilities of the subsidiary, not the parent. So the value of the parent in its ownership of the subsidiary is after you've taken account of those things. So therefore, the creditors of the subsidiary come out before the shareholders. So taking security over the shares is worth the square root of nothing in reality. We need to take security from the debtor itself if we're going to clobber its assets. And as we've established, we want to make sure that all of that package covers all of the finance. So in English law, can we do all of that? Well, English law basically says you can take security over real property. You can take security over tangible personal property. Which goods you can take security over intangible personal property. So yes, essentially in that scenario, it ought to be possible to grab the whole lot, subject to negative pledges and anti-assignment clauses and the like, and we can do it in all monies form. But there's a few questions that we've just got to resolve before we march in there with our size 10 boots and do all of this. And the first one really is, okay, we can take security over everything that we can see and metaphorically see if it's intangible, but what if it doesn't yet exist? So my example to you before, last year's apple crop, now in the shed, next year's apple crop. Possible or not possible? Well, in a physical sense, of course, next year's apple crop doesn't exist, so the value of the security, if we could do it, is worthless because it doesn't exist. But in legal theory, ignoring such important practical considerations, answer is yes. English law allows someone to take security over future property. And essentially what English law says is that when the property comes into existence, it is treated as being immediately subject to the security that was agreed before. So you don't need to rush off every time and take new security over the future assets because they're immediately and automatically covered within the net. So that's rather good if we're thinking about future cans of baked beans or whatever, isn't it? That we can devise it so that they will automatically come into the net. There are one or two little wrinkles in that, but that's the sort of the basic position. But if it doesn't exist, and we're taking security of it, logically, therefore, we can't have physical possession of it because it's not there. So the only security we can take over future property is non-possessory security. Possessory security, where you actually take possession of the thing, you can only take possession of it if it's there to take possession of. And possessory security involves actually physically having it in your hot little hands. So we're essentially talking with possessory security goods. And there are two types of possessory security. One is called the pledge, which is almost the oldest form of security known in English law. And a pledge involves possession, taking it off the debtor and putting it in your pawn shop or wherever it is. And if the debtor doesn't pay off his debt, you then sell the asset in enforcement of your security. Now, pledges used to be basically the poor man's method of getting money. Working class people who didn't have a steady amount of income often would have to go and give a pledge over some valuable item they owned, wedding ring or whatever, until payday, when they would go back to the pawn shop and redeem the pawn by paying off the debt. These days, actually, it's quite a fashionable thing. I understand that there are pawn shops operating in London where you sort of essentially decide that you and your girlfriend are going off to some exotic place for the weekend and you pledge your BMW for the weekend or whatever. And pick it up again on the Monday, having got all the money to spend at Longchamp or wherever you've gone. So that's a pledge. A lien is similar but not the same because it doesn't have a power of sale. And a lien essentially arises in respect of people who've done work on an asset. So I take my car to the garage to have it repaired. The garage has the right to retain my car until I pay it. Now notice the very restricted sense in which English law is using those expressions. They mean those specific things. The Americans, God help them, use them in a much more wide sense. They use pledge and lien and all that sort of thing in a more general security sense. We don't. They have specific meanings in English law, and they're those restricted meanings. Right, we've dealt with that. Let's deal with non-possessory security, which is much more interesting. So non-possessory security essentially arises by contract. I agree to give you a mortgage over my house. I agree to give you a mortgage over my intellectual property. I keep physical possession of the asset, but you have the security right in it. Now there are three types of non-possessory security in English law. The first is one I've already talked about, the mortgage. In technical terms, and it is purely technical, a mortgage involves an actual transfer of the ownership in the asset to the creditor. The mortgagor, the debtor, technically transfers ownership to the creditor, the mortgagee, and the law implies into that relationship the right of the debtor, the mortgagor, to the return of the title when he's paid off the debt, and that is the equity of redemption. Secondly, there is a thing called a fixed charge, which for most purposes achieves the same as a mortgage, except it doesn't involve a transfer of ownership. Instead, the law recognises that a security has been imposed on the asset. For most purposes, it doesn't matter whether it's a mortgage or a fixed charge. And then there's this wonderful thing which was invented in the second part of the 19th century, and it has been said, I'm never sure whether this was said fatuously or not, that English commerce in England could never have survived without it. And it is called the floating charge. Now, a floating charge is the form of security that you take over the cans of baked beans, the stock and raw materials that you are selling or using up in your business. And the characteristic of the floating charge is that not only does it cover new assets coming in, which you can also do with a charge, fixed charge, but it also allows the debtor to dispose of those assets free of the security. So the security applies to the assets whilst they are in the ownership of the debtor, and the assets can depart from the security in the trading business of the debtor. And it's only when the balloon goes up or the shutters come down, or whatever analogy you wish to use, that the security then fixes onto what's left. So it's the form of security that we would need to use in our example for the cans of baked beans and for the flour that's going into making the bread and the bread. Because we need a form of security that can allow the debtor to trade in those assets. And so when I go to the checkout counter with my cans of baked beans and bread that I'm buying, at the moment that the supermarket sells them to me, they leave the security. Hence the expression floating. It's floating there, but not actually attaching itself in a sort of an analogous sense until it's enforced when things go wrong. So let's just go back now and think about the example and those assets and the forms of security we might take. So our land on which we've put a building, which is in technical terms now part of the land. What sort of security would be best for that? Well, a mortgage. The land's not going to go anywhere fast, is it? So it's there, it's permanent, and it would be nice to get the most formal form of security we can get. What about the shelving and the refrigerators and the computers? They have a sort of degree of permanence to them, don't they? I mean, they're not being sold every day by the supermarket. So they're there, but they do wear out and get replaced. Would we expect our supermarket to ring up the bank and say, oh, we're ditching the computer and getting a new one? Or the shelving's looking a bit tatty, so we're going to pitch it out and get new shelving? Or the refrigerator broke down last night, Saturday night, and we need a new one on Sunday morning? Can you see that we're now sort of asking ourselves, well, okay, are we in the territory of fixed charge, which has nearly all the incidents of a mortgage, so the assets can't depart it without permission? Or are we thinking more in terms of floating charge, where they can depart And that's a question of law. It's not a matter of what the thing calls itself. It's a question of law. What in reality is its inherent characteristic? And English law hasn't quite properly resolved that one yet. There's no doubt that the floating charge is the only form of security we can take for the stock that we're selling and the goods we're using to make stock to sell. Now I'll ask you a question. What about the debts due to the supermarket by the credit card company, which in value terms are going to be worth a lot of money? What sort of security could we take over those things? And this has occupied English law for the last 50 years or so, I guess. It's now resolved, but what do you think? Bearing in mind how valuable this is. Floating charge, yeah, that's what the courts eventually decided. Because, again, if you think about it, the debts are not there forever as debts, are they? They are turned into cash, and that cash is used by the supermarket. You know, the credit card company pays the supermarket. The money goes into its bank account, and the money is taken out of the bank account to pay the wages and all the rest of it. So eventually, after an awful lot of case law, the English courts came to the view that you're only talking about a floating charge. Now, none of that would matter unless there was some problem with a floating charge. Labels mean nothing, but there are disadvantages in a floating charge, which I've listed for you. First is your security disappears automatically when the assets cease to exist in the hands of the debtor. And for reasons that I won't need to bore you with now, it's possible for other people to take security over those assets and get ahead of you in the game. There are statutory priorities. There are certain classes of people who get ahead of you in relation to those assets in a liquidation. And in an administration, the administrator can actually use the floating charge assets for running the business. So in a practical sense, yes, it's great to be able to have some form of security, but it's not as good as the other forms that I've mentioned to you. Right, we'll skip registration. That's boring. I don't want to muck around with that this morning. Priorities. A very quick word about priorities. Priorities are a problem because English law not only has sort of dreamt up this sort of wonderful panoply of security, but it decided, well, having done that, we ought to allow all sorts of different people to have competing security in the same asset at the same time. We could spend a week talking about how that comes about, but let's skip that and just take that as a fact. So in my example to you, let's take, say, the shelving and all the rest of it. It might be possible to find that somebody else has also got security over it, maybe because they took security over it when it was still future assets or whatever. So English law then had to devise a whole set of rather complicated rules to work out, when you've got competing claimants in that asset, who wins the race. Now, I think you might have looked at this a little bit when you've been talking about senior creditors and junior creditors and all that sort of thing. It's the same point, essentially, when you translate it into security. Enforcement. So this is when it really matters. Okay, the debtor's defaulted our financier wants to enforce his security. First point, enforcement of security in English law is a self-help remedy. You do not need a court order. All you need to say is, this is my mortgage, this is the asset that it secures, I'm enforcing my security, and away you go. And the only stop to that is, again, administration. If the debtor is in administration, you need either the consent of the administrator or a court order. But outside that scenario, you just get on with it. Marvellous. I mean, all you've got to do is show you've got a proper price, but that's pretty easy. And you just enforce. So literally, you turn up at the house, say, the money is now due, you haven't paid, get out. And if they don't, you break down the door and you put them out. And then you put a sign up in front of it saying, for sale. And you sell it. Easy. Simple as that. And of course, if it's actually money sitting in a bank account or something like that, you don't even need to go to all of that. You just say, that's my money, thank you very much. Now, the forms of enforcement are fairly straightforward. The one I've just described to you, sale. If you're talking securities, so stocks and shares, debt claims, that sort of stuff, there's an alternative which is appropriation, which basically means it becomes yours. And all you've got to show is that you've given a proper valuation of it. So if I've got security, and I'm talking corporate entities here, if I've got security over a portfolio of shares, and the debtor who gave me that security is a corporate, and I'm a corporate, then basically I can just, if the conditions of enforcement have come along, I say, they're my shares. Which is similar to an old ancient remedy that you might have heard about called foreclosure. Foreclosure was the method of enforcing mortgages in the medieval ages. It sort of died out about 300 years ago, and lo and behold, thanks to the European Union, we now have appropriation, which is very similar to the old remedy of foreclosure. Appointment of a receiver. I think I'll leave that till later on, but essentially you don't have to do the dirty work yourself. You can get someone to do it for you, called a receiver. So you send the receiver in and he gets all the flack and does it for you. A great scheme, because somehow or other the judges are meant to have dreamt up the idea that when a receiver is enforcing the security, he's doing it as agent of the debtor for the benefit of the creditor. How on earth? I mean, well, don't ask. Appointment of an administrator really is an insolvency process, but certain types of creditor can actually trigger the process. And then the fallback, if for some reason you mucked up your documents, so you didn't execute them in the right fashion or something like that, you can always, the fallback is go back to court and ask for the court to order sale. That's an admission by a solicitor of negligence, basically, if that's happened. Now, I've talked about security, and so the way that a creditor can get a right in rem in an asset by way of security, a finance creditor can do almost exactly the same thing in a practical sense, but not call it security. So let's just run through how finance might be extended in a non-security secured fashion. And let's just go back to our example and think about, say, the shelving and the refrigerators and the computer equipment. And let's also think about those monies owing to the supermarket by the credit card company, and see how we might extend finance on the basis of that, getting a right in rem in those assets but not actually call it security. So with the equipment, the way to do that is, rather than the supermarket buying it, the financier buys it and then makes it available to the supermarket to be used during the period of the agreement. And that may involve an arrangement under which ultimately the title will pass to the supermarket, or it may not. How did you all get here from when you came to Cambridge from abroad? Most of you, I suppose, came on an aeroplane. Did any of you come by train? A couple came by train. Ship? Anyone come by ship? No, they don't do that any longer. So aeroplanes and ships. Well, forget the ships for a minute. Let's think about, the train. Let's think about the aeroplanes. And when you got on, that aeroplane no doubt had a lovely name on it. British Airways, if you were silly. EasyJet? Yeah, EasyJet. Who else? What other airlines? KLM? Virgin Atlantic? Ryanair? Oh dear. Any others? Turkish Airlines, okay. So they all had these wonderful names on them, and you thought, oh good, I'm getting onto a KLM plane or a Turkish Airlines plane. Or anyone come on Singapore Airlines? Yeah, this example doesn't apply to Singapore Airlines because they actually own everything. You can always tell when Singapore Airlines is about to buy a new fleet of planes because there's a manipulation of the Singapore dollar against the US dollar. Ignoring that. So all these other airlines, Jumbo Jet comes in at what, $400 million, something like that. And very few airlines actually, other than Singapore Airlines, which got so much money they don't know what to do with it. Everybody else somehow or other has to finance that aeroplane. Now they could do it in the way we've been talking about before, borrow the money from a bank, give the bank a mortgage. Fine. Alternatively, and what usually happens is the bank buys the aeroplane from Boeing or Airbus and leases it to the airline for 12, 15 years. Now, in economic terms, that is almost exactly the same as borrowing money. The economics of it are worked out in the same way as borrowing money. So in the payments that the airline's making to the financier, it's somehow or other repayment of capital with interest. And you can muck around with the sort of, at what point the capital gets paid depending on the ultimate value of the aircraft at the end. But it's essentially what it's doing. But instead of it being a mortgage, the bank is protecting itself by actually owning it. And so the lease says, you have the right to use this until you default or the lease period comes to an end, at which point the bank will be entitled to repossess its asset. Now, you probably, one of the main reasons that you'll do it that way rather than borrowing the money is tax. Most tax jurisdictions around the world have a regime where someone who buys a capital asset can claim a tax deduction against the purchase price. It's only worth doing if you're stuffed full of profits against which you can write off the capital value. These are called capital allowances. Who's stuffed full of unseemly amounts of profit? Answer, banks, not airlines. So the bank claims the tax deduction for buying the thing, and that's then computed into the financing cost. So the bank keeps some of it and gives the benefit of it in the lease rentals. So we could do that with our supermarket as well, couldn't we? We could look at the refrigerators and the computers and all that sort of stuff and do it that way if we wanted. And then with the debts that are due to the supermarket by the credit card company, we could take that into account in our security package, so our finance takes into account that we've got security over those. Or alternatively, for that bit of it, either our bank or some other financier could extend credit by buying those debts ahead of their payment date. So we know that a debt created today is probably going to be paid to the supermarket in, say, 6 weeks' time. So the financier buys the debt today from the supermarket, expecting that it will be paid out in 6 weeks' time when the debt's paid. Now, if you were doing that, how would you calculate the price that you pay to buy the debt? What are the two factors that you would take into account in working out the amount you should pay today to the supermarket for the debt that comes into existence today and will be paid in 6 weeks' time? What are the two factors that you would take into account? Risk of default, yep, and yeah, a discount because you're now going to have to wait 6 weeks to get your money back, yeah? Now, the second element of that's going to be pretty much the same for everybody, isn't it? The first element's going to change, isn't it? So it's the risk, the credit risk element on the debtor who owes the money actually paying the debt. That will be the significant difference in the discount that is charged to the supermarket for buying the debt from it. It's an interest factor, isn't it, in reality? And that, in simple terms, is normally called something like factoring. And in more esoteric, glorified, high finance, overweight bankers' terms, when they're buying portfolios of these things, securitization. Securitization is nothing more than a glorified form of factoring of debts. Okay, it's got some bells and whistles in terms of how you structure the purchasing thing and where that money comes from, but that's what it is. Invented years ago. Yeah.
Sorry, is that similar to forfeiting?
Sorry?
Forfeiting.
Forfeiting is a similar thing to factoring. Yeah. Doesn't happen so much now. It used to apply up till, you saw it quite a lot until about 20 years ago. Not so much now. A quick word on subordination. The basic rule in English law is that a debt's a debt, and the only way you can improve your position is take security for it. That's the basic rule. But then some idiot dreamt up subordination. And this was meant to be yet another wonderful idea which would never go wrong, and everyone would earn tons of lovely income on it and live happily ever after. And essentially what subordination involves is someone who is already in the position of an unsecured creditor agreeing to defer his rights to payment behind one or more other unsecured creditors. And that's great. The reason that you normally do it is because you're paid a higher rate of interest for it. So this is meant to be money for old rope. Yeah, terrific. Well, the ordinary debtors are getting 1% over LIBOR, the subordinated creditors are getting 2% over LIBOR. Why not? Well, of course, the reason why not is it's terrific until everything goes wrong, and then suddenly you're behind the people to whom you're subordinated. Now, for a very long time, until about the mid-80s, subordination as a technique in English law was rather questionable, because there's a basic principle of English insolvency law, which is that all unsecured creditors rank equally in an insolvency. And people sort of scratched their heads and said, well, how can you reconcile that basic principle of insolvency law with the idea that some unsecured creditors are more equal than others? Well, eventually the courts managed somehow or other to reconcile that and said, well, and the way they did it was they basically said, yes, but if you're stupid enough to agree that you rank behind everybody else, then that's your fault. And that agreement can be enforced against you. So subordination does work as a matter of English law. And there are essentially two techniques. One is a contractual subordination, where essentially it is agreed between creditor and debtor that the creditor will not be paid ahead of whoever these senior creditors are. So that may be a particular senior creditor, or it may be all other creditors. And that's the technique you've got to use, by the way, where you're dealing with a jurisdiction that doesn't recognise trusts. The alternative is to use a trust mechanism where essentially you agree that you won't be paid ahead of others, and if you are, the money will be held by a trustee for the benefit of the senior creditors. And as I indicated to you earlier, those subordination mechanisms have become popular in certain types of capital markets financing and became quite an important tool, so it was thought, in bank capital adequacy arrangements, where essentially people didn't want to be shareholders but agreed that they would be treated as if they were, so their right to be repaid in a doomsday scenario was only after the senior creditors, the senior unsecured creditors. Right, we've got just a few minutes to work our way through insolvency. Just to mention the regimes so that you know what they are. Bankruptcy for individuals, we don't need to worry about that any further. That's individuals and we're not terribly interested in them. I'm more interested in corporates. So let's start with winding up or liquidation. This is death for the corporation. It comes about in either of two ways. The first is called voluntary winding up, which is basically where the shareholders resolve that the game's up and that the company should go into liquidation. Now, they may do that for one of two reasons. They may do it because the company is bust. It can't pay its creditors. And rather than waiting for a creditor to take proceedings, they will preempt it by resolving to be wound up. And if that's the case, that's called a creditor's voluntary winding up. The alternative is that the company's solvent, but the shareholders just decide that it ought to cease business. Typically one finds that in a family company where there's been a falling out between the members of the family. So the company actually is perfectly viable, they just can't stand each other. And the way out of it is to wind the thing up and distribute the assets in a solvent winding up, so everyone's going to get paid out. What's left is then distributed amongst the family members, and they can go and set up their own businesses with the separate assets. whichever it is, winding up or liquidation ultimately leads to the death or the extinction of the company. Now, the problem with that is in what I've just said, that if that's the route you go, then that's the end of it. And until 1986, that was it. There was no other way of dealing with it, really. And people said, well, in these situations, it may be possible to salvage something from the wreckage. We need another procedure which, one, gives time to the business to try and work itself out. Or, if it can't do that, at least more time for a more orderly work winding up so that you can get a better value for the benefit of the creditors. And that was invented in 1986 and is called administration. And essentially what happens in administration, companies bust, but instead of going into liquidation, an insolvency accountant called an administrator is appointed to take charge, to take control. So the existing management are basically dispossessed, and the administrator moves in and runs the company. And at the same time, a fence goes around the company which stops all the wolves. So all the baying creditors, whether secured or unsecured, are sitting outside the fence and can't get in it. And again, this is to allow the administrator to come up with a scheme to try and save the company. And if you look at the Insolvency Act, you'll see that in doing this, there is a sort of a cascade of purposes. The first, and the one that the administrator must try for first, is saving the enterprise and bringing it out after the rescue period. Or, if not that, at least a better deal for unsecured creditors than would be achieved in liquidation, or just enforcing the security for the benefit of the secured creditors. Sadly, those very worthwhile ideas haven't translated into practice, and administration normally works out as just another form of liquidation. Very, very few enterprises have managed to come out of administration. Fact of life, really. There's something similar in America, but it's different. It's called Chapter 11 bankruptcy. The idea, again, of trying to save the enterprise, fence going around it and so on, is the same, but there are a couple of significant differences. The first is that you do not have an official like an insolvency account. There is a court supervisor, but the management remains in control. They've got to come up with a plan which is voted on by the creditors, but the management remains in control. Debtor in possession proceedings, essentially. Or the cynical may say that the lunatics are running the asylum. You know, the guys who got the thing into the trouble are then tasked with getting it out of trouble. In this country, we said, no, we'll put a completely fresh pair of eyes in. So that's the first important difference. And I guess the second is that is in financing the enterprise while it's in the intensive care unit. In America, the management can raise funds which can get priority over existing creditors. In this country, that can only be done with the agreement of the existing creditors. So so-called super priority financing applies under Chapter 11. It doesn't apply here.
I was going to ask, I don't know if it's something that applies in the UK and the US, but how do you treat breach companies or breach bank structures, whereby, for example, in Nigeria, where a bank is insolvent to an extent, you have some government body that comes on board, buys up these bad assets of the company, changes the management, possibly changes the name. And there are arguments whether that's an administration or is a winding up or the company doesn't exist or who owns the share. That's one question. The second question is for specialist companies like that, when you take the license off that company, does the license of the bank kill it as a company? Or when you take away the license of the bank, does it go back to being just an ordinary company?
Okay. Let's take the second of those questions first, because that's the easiest question. Basically, banks can only operate as banks if they've got the right licenses. Once the license is taken off the bank, that's the end of it as a bank, and it's just then a corporate entity. But of course, at this point, it can't be in business, so all you're doing is realizing the assets. What you can do as an intermediate step is restrict the license, so that you restrict it, for instance, from new business. So you just leave it with a sufficient license to run down the business. So that's the licensing point. The other point you raise is, well, hang on a minute. Banks, although they are corporate entities, are different types of entities to an ordinary corporation. And that became apparent in this last financial crisis, that it doesn't work to treat a bank as an ordinary corporation. You need to do other things because of the nature of its business and the nature of people that have got a relationship with it. So what happened in the UK in 2009 in the Banking Act was a whole set of new insolvency regimes were introduced for UK established banks. And these, to some extent, allow you to use liquidation or administration, but also have a thing called a resolution regime in them, which essentially allows the authorities to take the business out of the bust bank and transfer it into another entity. And there are various mechanisms by which you can do that. And they also allow for the liabilities either to remain where they were, or to be transferred with the business, or to go somewhere else. And the idea behind all of that is to try and preserve the rights of ordinary depositors and to try and keep the bank's basic business running. First time that was used was with a bank called Northern Rock, and it's been used about a dozen times since. And at the EU level, there's a new directive which came out at the end of last year, and for the life of me, I'm just trying to remember the name of it. Where are we? I can't find it for a minute. I'll come back to it. There's this new directive of the end December 2013, which on an EU level sort of is going for the same sort of ideas of resolution and so on. There's also bail-in, which is, you may have heard the expression bail-in. It's basically where bondholders and the like can be forced to give up certain of their rights to repayment. So they're treated sort of as if they're quasi-shareholders. Now, that can sort of be used as an adjunct to the subordination techniques that I used, referred to before, or imposed on top of it. So is that the sort of thing you're thinking about?
Mark, in response to the first question.
The first question was... I don't know, describing a better structure where the government, through its agency, finds these bad assets of this bank, possibly changes the name, and because something that's going on right now in Nigeria, and then there are questions whether those banks are, first of all, still companies,
and or so that the original shareholders could probably go back, as you said, some other form of business that's not probably a banking business, or these companies automatically be paid and no longer.
If the regulatory authorities have intervened and taken the assets out, then essentially what you're left with is a shell, with or without its creditors. So there's nothing left, is there, that you could make a viable business out of. What the authorities seeking to do there is to leave the carcass behind with its liabilities, take out of it what's good, put it into a new entity.
They take the liabilities.
Sorry?
They take the liabilities.
Yeah.
So they take the liabilities. So the government agency takes the liabilities of this company, which at that point
Or leaves them in the shell.
they take the liabilities.
They take the assets.
The liabilities of the company.
The liabilities of the company, its creditors, are left with it, can be left with it, or they could be put somewhere else. The bank has creditors, people to whom it owes money, and its own customers, its debtors. Right? So you might take the business relating to the customers and put that, at least the good ones, put that into a new viable entity, leaving the old bank just as a shell, owing money to its creditors to be resolved as best you can with whatever either the government's put in or the money that was transferred across for the as consideration for the transfer of the business. Okay? Talk to me more about that if you want to. I think just in the minute or two we've got left, let's just have a look at the order of creditors in a liquidation, which I hope will summarise most of what we've been talking about this morning. This is essentially liquidation, and it sets out the order of creditors. Who gets what out of the pot? The first out are those who've got fixed security rights, set-off rights, and ownership rights. So our lessors, those sort of people. They come out first basically because of their right in rem in the relevant assets. Then comes the liquidator for his costs and expenses. Then the preferential creditors, so the people who by law are given a preferred position, the unpaid wages, that sort of stuff. And then by virtue of 2003 legislation in the UK, out of floating charges, a certain amount, about 20%, has to be set aside for the benefit of unsecured creditors. So you can see there, by statute, we're mucking around with the basic principle of security law for floating charges. Then what's left of the floating charge for the floating charge holder? Then come the unsecured creditors. Now, at this point, we're probably completely cleaned out. So the rest of it, from about this point on, is almost theoretical. But let's carry on. So unsecured creditors, then the maniacs, as I described them, the subordinated creditors, and then the shareholders. And I have been a shareholder in that position, so I've felt the pain. Right, I think that's enough. Are there any quick questions? I mean, you're welcome to come down and talk to me afterwards if you want, but any quick questions? And I think in saying all of that, I forgot the second break, didn't I?
That's okay.
Oh well, bad luck.
One break if you want.
Thanks very much, Andrew. That was fantastic. We've come across so many